Hello and welcome to BarChat. My name is Doug Brown. I'm the Executive Director of the Connecticut Bar Association, and I'm pleased to have with me today two of our members on the topic of options in alternative dispute resolution. Our first guest is Peter Benner. Peter is an independent mediator, arbitrator, and resolution consultant with Benner Resolutions. And our next guest is Jane Beddall. She's a mediator and principal in Dovetail Resolutions. Welcome, Jane. Welcome, Peter.
Thank you.
Good to be here.
Nice having you. Thank you for taking the time to come to BarChat with us. You're both former chairs of the Alternative Dispute Resolution section of the Connecticut Bar Association. Jane, let me start with you. From the perspective of the section and with your experience, what do you see as the current or key issues that our members should be aware of regarding alternative dispute resolution?
Well, Doug, aware is the key word, absolutely. What we see as a section is that there are lots of very good attorneys in Connecticut still aren't too sure about alternative dispute resolution, or ADR as we tend to call it. They know mediation and meditation are different. Mediation and arbitration, they're not so sure. So a real quick nugget is that in mediation, the mediator works with the parties to create a resolution to their conflict that works for them. Arbitrators actually make decisions about who wins and who loses. So beyond that group, there are folks who really do know what mediation's about, but they've never had any experience with it at all, and they think it's irrelevant to their practice. And then there's an even smaller group who are experienced, but their experience is very limited. It is really only with the evaluative and directive type of mediation, which is the most common in Connecticut at this point. So there's a lot of potential that's not realized, which is why we think awareness of how much more you can do with mediation in your practice is essential.
What are some common objections people might have to the misconceptions about mediation and why they might not even consider it?
I think part of it is it has just kind of gotten into a very narrow rut in that there are only a couple of practice areas where it's common. And that, of course, would be divorcing couples, and then commercial and personal injury cases on the eve of trial. But there's much more that it can be used in. There's also a sense of, well, I don't really know what it's about, so I'm not going to ask. Well, ask. It's okay to ask. we won't tease you or give you a hard time if you're not really familiar with how the whole thing works. There are also different types of mediation. As I mentioned, most in Connecticut are familiar with a very directive approach, very evaluative. By that I mean it's just about the money. But in fact, there are opportunities to use it much more broadly with different types of mediation, and sometimes with different purposes beyond simply these people need a resolution to their dispute and then they're going their separate ways.
So how could our members who might want to incorporate this into their practice and working with their clients, how might they get started or do it effectively?
First is to just know what's out there. And one thing that Peter's going to talk about a little bit, I'm looking forward to hearing more about this because it's, I think, going to be a very exciting program in June, is opportunities to learn more at the legal conference. But more generally, it's just thinking about what's another tool I can use even when I'm a counselor, not just as an advocate.
Interesting.
Because there are opportunities earlier in a conflict, before positions have hardened, before the whole matter is escalated, to try to serve your clients in a way that serves a broader purpose. For example, there would be situations where really your client wants to stay in this relationship with a person with whom they're in conflict. And that could be situations of estate planning that just can't get done because they can't talk about it. Business partners, they'd like to resolve it and stay together. Healthcare, repeat players. They are in it together. They can't get rid of each other. They need to resolve it. And then finally, what you might think of as land use and environmental issues, whether they are businesses who are side by side or families in a neighborhood. They really don't want to end this relationship. They want it fixed. So it's an opportunity for lawyers to be more creative in their problem solving.
So a lawyer who has in a conflict early, say with business partners, for instance, if they want to get involved in mediation, it's not that they're losing control of their client, it's just they're trying to do something short of winding up in the court system.
And serving your clients better, which is really, I think, what it's all about. And there's some opportunities there that we think, as a section, are often overlooked. Some possibilities to really serve your clients better, get them a better result, and improve their satisfaction with their lawyering experience, if you will.
Terrific. You know, coming up on June 15th of 2015, we have our CBA annual meeting in Connecticut Legal Conference, and we'll have over 50 programs, and the ADR section is going to be there helping lawyers start to learn how to do this. Peter, you're involved in that program. Can you tell us what you expect to be doing at the legal conference in June?
Yes, thanks. We've organized a program that really is focused on very much what Jane has talked about, raising awareness, but also focusing on the concept of improving client service. Okay. Because I don't really think that lawyers necessarily consider dispute resolution options directly in connection with the improvement of client service and the improvement of client satisfaction and the likelihood of increasing client loyalty.
Interesting.
But that's a very much one of the things that is unrecognized as an option that if you think about when you're engaged by a client, when a client comes to you with a dispute, if you think in terms of the various panoply of options that are available to you that used to be considered alternative, thus the term alternative dispute resolution, which really in the mainstream now, and I think most lawyers recognize, are no longer alternative. They're just a part of the overall toolbox.
Right, right.
And so the question is how to most effectively utilize what those tools are as early as possible so as to get the least expensive result possible, so as to tax client resources as little as you can, as well as most effective client result. It really is a client-oriented process.
Sure.
What we also like to highlight, or at least I like to highlight when I speak about this, is consider also the fact of the impact on your own practice, how your own practice can be enhanced, not only by the fact that you have happier clients, more satisfied clients,
sure,
clients with better outcomes, but your time is more effectively utilized, which today is obviously at a tremendous premium, given the pressures on lawyers, both financial and otherwise. So it's an underutilized, vastly underappreciated resource. And people understand it, people know it, but they don't necessarily put the dots together, if you will, connect the dots to utilize it as in the manner that Jane has described.
So, you know, it seems like the idea of mediation for client service, you know, pretty self-explanatory. You mentioned the idea that making your own practice better and making you more efficient. When you began doing this, you've been doing it for a long time, what were some things that you saw that made your practice and your life as an attorney better by providing mediation or quote alternative pathways to your clients?
That's a really good question in the sense of what's happened with mediation and the options and the opportunities, say, over the last 20 years. I mean, the whole concept really began in the getting to yes era of the early 80s. But really over the last 20 years, mediation, because of a lot of the thinking that's been done, a lot of the academic work that's been done, a lot of the practical applications that have been developed, mediation has really come into its own. And when we say mediation, we're not necessarily talking about what people, as Jane indicates, think about it in the classic sense. It can take on any type of permutations. It's really a very creative process. And you can oftentimes think of the process as the problem. You look at a dispute and you think, all right, what is the best way, the best process that I can use to effectively resolve this dispute for my client? So often, lawyers, particularly litigators, of which I was one, reformed,
recovering litigator,
will default to litigation, fight for 2 years, position themselves and posture in such a way as to obtain the best result for their client, which is their objective, and sometimes the result can be very satisfactory. But in the meantime, they potentially have wasted tremendous resources, tremendous amount of time, and spent and also created significant antagonism between the client and the opponent, as well as perhaps bypassed opportunities that could have been available earlier in the case. So one of the things that I preach, if you will, is that considering engagement earlier on a more consensual basis, you don't have to settle the case, you don't have to make any concessions, but exploration of what the possibilities are can enormously advance what the possibilities are for a resolution early or at some later stage on a more favorable basis. And surprisingly, more often than not, can bring the case into focus in a way that eliminates that 2 or 3 years of what essentially can be wasted time, sometimes looking for the smoking gun, sometimes trying to outlast the opposition in a war of attrition. So it's, you know,
and litigation is obviously high stakes, and in these days, even if you're on a litigation path, you're going to get diverted most likely into some alternative program before you ever get your day in court anyway.
98% of cases.
That's
settle.
right. That's right.
So why not at least give it a try earlier on before you go through
so that's a good point, Jane. When we think about, I mean, this is obviously what you have you guys have focused your careers, but are there some techniques that a lawyer in regular practice can do before they have to go to a professional who does this as a third-party mediator? That if you were talking to a lawyer saying, here's some techniques you can try the next time you have a client intake or your first interaction with clients to help them get comfortable with this idea.
I think actually going back to your question a moment ago and Peter's response, it's partly a perspective. It's when I'm talking to my client who has come to me, and some wonderful attorneys I've learned from over the years just continue to stress, you're there to solve a problem. You're not necessarily there to win in court. They want the problem solved. That's why they came to you as a lawyer. Hear the whole problem. Because sometimes one thing that mediators will talk about is interests and positions. My position is that good for nothing, I'm right, he's wrong. Okay, you can let your client say that for a couple of minutes, and then maybe a deeper and broader conversation about, well, what is it really you would like to accomplish? Where do you want to go from here? And sometimes there's much more to it than that. And sometimes they are happy to start thinking that way if given the opportunity. But they haven't had that opportunity and haven't looked at it that way.
So it's almost as if when you're doing an intake with a client as an attorney, rather than thinking about what kind of litigation will these facts lead me to, trying to ask why more than once or twice and understanding what is the real outcome the client wants and engaging and really kind of slowing down to listen and think about better ways to accomplish their goals.
And what can be interesting sometimes, and it's a place where an attorney would hate to be caught flat-footed, is that there are some very savvy clients out there. And if they walk in the door and they've got something in mind other than we're going straight to court, you want to be ready and conversant in, well, what are some of the other options that they may have heard of in some other context? You know what they're asking you about. If they start to ask you about, well, is there any other way? You would hate to say, not that I know of, because then you're not serving them and you're certainly not inviting client loyalty if you're not as up to date as your clients are.
Well, and in this era of self-represented clients and those who believe they can go on the internet and become a legal expert, they're coming in much more educated than they were even 5 or 10 years ago about their various options. So,
I could just jump in because I really would like to reinforce something. Jane makes a great point that really deserves emphasis, and that is we think in terms of the difference between interests and positions. And so oftentimes what litigators or people who are pursuing a lawsuit are doing is advocating a position. And obviously, in virtually every case, your position is going to be adverse to the opposition. What doesn't necessarily have to be adverse or may not be adverse is what are your common interests? What is it that you're mutually seeking to accomplish and that can be accomplished by focusing more on what it is the outcome needs to serve, rather than who needs to win or who needs to lose. And when you put it in that framework, all of a sudden clients think, that makes sense to me. And I can see how that resolution might allow me to reach an agreement with the person I'm in a dispute with without having to win or without having to lose. We talk about win-win, and that's perhaps the optimal. But if you look at it from the perspective of interests, if an attorney can think in those terms rather than be the gladiator who's advocating a position, client service becomes potentially much more enhanced.
I agree with that, and I'll share my experience in working with entrepreneurs and lawyers and just in life, lawyers talking to each other at the end of the phone, thinking about the outcome you want when you start the conversation and maybe what common interests you have with your adversary on the other end of the phone. Maybe it can help us take a step back more towards a civil practice, not the litigation, but civility and collegiality, because in many times you might be dealing with a difficult client, your opponent might too, And you even have common interest as lawyers to help bring that resolution to a dispute, even if your client's objectives are different.
Right.
I want to thank you guys for coming in and looking forward to the program on June 16th at the Connecticut Convention Center.
We have more time to lay this all out.
Yes, we'll have you have 90 minutes, and it's a full-day program at the Convention Center June 15th.
Right.
So thank you very much for being here, and we'll see you in June.
Okay, thank you.
It's a pleasure.
Thank you.
Yep.